Hey everyone, my name is Nico Perrino. I am the Executive Vice President at the Foundation for Individual Rights and Expression. We're a public advocacy education organization devoted to defending free speech rights across America. Now, some of you might know that I'm writing a book at the current moment. I'm writing a book about the fight for free speech over the course of the 20th century. And a big part of that book is interviewing the civil libertarians who made the First Amendment and its protections for free speech and free press what they are today. And one of those guys that I interviewed is Ira Glasser. He's the former executive director of the ACLU from 1978 to 2001. And he said something to me in the course of the interview that really stuck with me. He said, "New law is like cement. If you let it sit too long, it hardens." Now, he used this quote in the context of telling me about the ACLU becoming involved in the fight to apply civil liberties protections to the internet in the early to mid 1990s. Now, Ira, for his part, described himself as this old curmudgeon. He retired from the ACLU in 2001, never having had or even used a computer. But there were young people at the organization, like this guy, Barry Steinhardt, who took it upon themselves almost as their personal burden to educate Ira Glasser and others within the organization who weren't familiar with the internet about its importance. And Ira very soon learned that it was going to be a revolution similar to the printing press revolution for the distribution and dissemination of knowledge. And Ira came to understand that if the First Amendment wasn't going to apply to this new means of speaking in roughly the same way it applied to those old ways of speaking, that free speech would really be wounded because in a short period of time, the internet would be the main way in which we come to speak. Now, before we move on here, I want to take a step back and do a bit of a First Amendment primer for those of you who don't work in the First Amendment space. The First Amendment is the First Amendment to the United States Constitution. It says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for redress of grievances. That's me, a much younger Nico Perrino, sitting there atop the First Amendment block in Independence Mall. Behind me is Independence Hall, where the First Amendment, where the Constitution and the Declaration of Independence were ratified. And behind that is where Fire's office is, in that building right there, overlooking what is thematically appropriate, the Independence Hall, where the Constitution again was ratified. Now, the important thing to understand about the First Amendment, is going to be important for the rest of this conversation, is that it not only protects the right of speakers to speak, but also listeners to receive and access information. And despite its admonition that Congress shall make no law, Congress has made laws accepting certain things from First Amendment protection. You might sometimes hear that people are First Amendment absolutists. That's more kind of like a vibe than a reality. Most people aren't First Amendment absolutists. Indeed, at FIRE, we think that the balances that have been struck with these exceptions, incitement to imminent lawless action, fraud, speech integral to criminal conduct, obscenity, most free speech people have a problem with the obscenity exception, are generally good balances between certain societal harms and the protections we want to have for our right to speak freely. The other important thing to recognize about the First Amendment is that it applies regardless of the medium that is used to speak. So I'm up here speaking, I am protected by the First Amendment. If I write something on social media, I am protected by the First Amendment. If I want to communicate a message by burning the American flag, according to the Supreme Court, I am protected by the First Amendment. And if I want to use a tool, and this is important, a tool like the internet or like a printing press to communicate my message, using those tools is also protected by the First Amendment. Now, the big challenge that civil libertarians like Ira Glasser and Barry Steinhardt and the ACLU colleagues, the Electronic Frontier Foundation folks had when the internet came around was the fear surrounding the internet. Now, this was not unusual. Civil libertarians understand that every time there is a new technology, there is going to be a fear associated with the unknown. You can go back to the printing press, right? The printing press was invented, and then you had countries from England to Spain to France, anything the Catholic Church touched that tried to license not only presses, but those articles or books that were distributed via the presses. You also had movies Most people don't realize that when movies first started coming out and the Supreme Court tried to figure out whether the First Amendment applied to communications via the movies, the Supreme Court said, no, it didn't. This was a case from 1915. And so as a result, you had film licensing boards in many states. You also had the development of what was called the Hays Code. This was an industry self-regulation that was trying to get in front of some of these state licensing boards that was in place until 1968, despite the Supreme Court overturning its earlier ruling in 1952, saying that, yes, movies are a means of expression. They are protected by the First Amendment. This goes back to what Ira was talking about before, that new law is like cement. If you let it sit too long, it hardens, and even the self-censorship that comes along with it. But then you also have radio and broadcast television. You got the Radio Act of 1927, you got the Communications Act of 1934 that gave the government the ability to regulate these media in the way that it couldn't with print media. This is how you get things like the FCC being able to regulate George Carlin's 7 Dirty Words, or the recent Jimmy Kimmel fiasco that I'm sure you're all familiar with. Early law said that the FCC could regulate in the public interest or news distortion and all these other different standards that I think are bullshit, especially now that you have streaming and podcasts and all these other media communication. But even there, you do have at least a plausible justification in that these communications technologies use public airwaves, the radio frequency spectrum, and that therefore there's like this interest that government has in regulating what is disseminated on them. So you have essentially two standards that the First Amendment applies to media and communications as the internet is. You have the broadcast standard, and then you have the standard for everything else. And Chris Hansen was a lead attorney at the ACLU in the 1990s. And he said the ACLU was seriously afraid that the broadcast TV model would be applied to the internet because it, like television, comes into a house on a screen in a box, and you don't always know what you're going to see when you click. Well, lo and behold, Congress did what it often does with new technologies. It tried to regulate it, and it tried to regulate it through what was called the Communications Decency Act, which criminalized the knowing transmission of, quote, indecent or patently offensive material to minors over the internet. And indecent is a word that comes from broadcast regulation. So you can see why the ACLU was very concerned about it. There is no decency exception anywhere else in the First Amendment if you're talking about print and whatnot. And if you fall, this was a criminal statute. So in inflation-adjusted dollars, you could be fined up to $500,000 and 2 years in prison if you ran afoul of it. And what it effectively said was that you need to sanitize the internet to only that what is fit for children, or put your content behind an age gate. Now, you can see the panic that was struck up as this regulation was being put forth. Time magazine in the summer of 1995 ran this headline: cyber porn. You have a child mouth agape looking at a computer screen in front of a keyboard. Can we protect our kids and free speech? And so it was a moral panic that led to an overwhelming passage of the Communications Decency Act. And the ACLU understood that often these regulations are put forward in a way to censor speech surrounding children and issues of sex. And Mike Godwin, who was the first attorney at the Electronic Frontier Foundation, was worried that in a world in which we increasingly received content through computer networks and other electronic media, the First Amendment would be marginalized and made even irrelevant if the Communications Decency Act was allowed to stand. So the EFF, in partnership with the ACLU and a number of other organizations, sued over the Communications Decency Act. And what you ended up getting was what has been described as the Magna Carta of the internet. And this is a Supreme Court ruling that was unanimous in part, 7-2 in other respects, that held that the CDA lacks the precision that the First Amendment requires when a statute regulates the content of speech, and the breadth of the CDA's coverage is wholly unprecedented. The decision went on to say that it interferes with the rights of adults to obtain constitutionally protected speech and reduces the adult population to reading only what is fit for children, likened it to burning the house to roast the pig. Mike Godwin, commenting on this years later, said that the Reno case left him wondering, as a civil libertarian lawyer, for years whether he ought to retire from civil liberties work, my job being mostly done. He told me that he didn't think he would see the seminal Supreme Court applications of the First Amendment to the internet during his lifetime. He thought he might very well retire before that happened. And if you look at movies, for example, I'm sure there were many people who worked on that case who never saw that Supreme Court case overturned. So that brings us to artificial intelligence, right? I'm writing this book, I'm reading these stories, I'm talking to Mike Godwin, I'm talking to Ira. I can't find Barry Steinhardt Fortunately, I don't know if he's still with us, but the vibes seem very similar with artificial intelligence. Artificial intelligence is a tool for communication. You can make movies using it. You can write essays using it. You can create images using it. And you can also access information and consolidate information and create new information that you never had the ability to do before, much in the way that people in the 1980s and 90s were able to do with the internet. And Joel Mokyr, who just won the Nobel Prize, has recognized this as well. He says AI is going to be to information very much like what the personal computer was. It will aggregate information at a dazzling rate. It will make us more productive. It will give us a much better access to knowledge. And it's important to understand, Tyler Cowen wrote a great essay for the Free Press earlier this week about applying free speech and First Amendment standards to artificial intelligence. But he got one thing wrong. In the headline, he said, should artificial intelligence receive First Amendment protection? I would tweak that a little bit to say, artificial intelligence is a tool. People have rights. Tools don't have rights. But to the extent we use artificial intelligence tools, and I'm talking here about the expressive artificial intelligence tools. I'm not talking about full self-driving or the zip lines that use artificial intelligence. Those can be regulable. Expressive, communicative tools like LLMs, to the extent we use them, we have rights to use them, and we have the right to receive the information that comes from them. So you have this revolutionary new tool for communication, information retrieval, and knowledge creation. Some of you who work in spaces, maybe you're younger, you're trying to teach your older colleagues how this thing works, much like Barry Steinhardt tried to teach Ira Glasser how it works. You also have the rush to regulate. So you've had something like 2,000 AI laws that were proposed over the last 3 years. Now, not all of them implicate the speech concerns that I have, but some of them do. We've had laws in California, Colorado, Texas, and not all these laws are motivated by animus. Some of it, as Dean Ball, who's competing with me for this talk right now, said, it was motivated by an urge to do something about AI, just like James Exxon and Chuck Grassley in the 1990s were motivated to do something about the internet. But this moment is different in some other ways. One, we don't have a big monumental SCOTUS ruling. So we talked a little bit about the AI moratorium, had a national conversation about it, didn't get put into place. But you effectively got an internet regulation moratorium from the Supreme Court in 1997 in the Reno v. ACLU case. It said you effectively can't regulate what's on the internet, its expression, its content. And in fact, you've only really had one judge that has assessed the First Amendment questions related to artificial intelligence. And that judge, coming out of a case in Florida, said that she was not prepared to hold that an AI's output is speech. She said in the decision that she's not convinced that words strung together receive First Amendment protection when used through artificial intelligence. I would say words strung together is the definition of speech. But that was on a motion for summary judgment, so we're hoping that decision will be returned later. You also don't have Section 230 protection necessarily. Now, I could go deep into Section 230. This is the liability shield that interactive computer services have who host party content. The idea being that the person who posts the content, the third-party user, should be liable for their speech, not X or Meta who hosts that speech. Well, is artificial intelligence protected as well? I mean, a lot of what you get comes from a third-party prompt. The question remains open. But then if it is, then pretty much artificial intelligence isn't liable for anything that it produces. And that doesn't quite work in the same way as it does with social media. But I would argue that we don't need this rush to regulate, that much of the harm that these lawmakers are concerned about with regard to artificial intelligence can be addressed by extending not only the First Amendment's existing protections for speech, but also their existing exceptions that we were talking about earlier. Things like defamation, speech integral to criminal conduct, truth threats, obscenity. So I wanted to take some time to talk about some of those harms that people are really worried about that motivate a lot of this legislation. And I should say here, anytime you're talking about an exception to the First Amendment, it's going to be a very fact-intensive analysis in a court. So I'm talking here about things in broad brush. We could go into the nitty-gritty, but these are generalities. One thing people are really concerned about are deepfakes. What's the principle here? Deepfakes are hyper-realistic renderings of actual people's image or voice. And generally, there's no hyper-realistic exception to the First Amendment. In fact, if you go into history, there was an effort to pass a law to prevent essentially photoshopped images of people sitting with the president. In this case, it was President Taft earlier in the 20th century, because I don't know, it gave people the false impression that they were at a place and meeting someone that they weren't. You can do that. Photoshop is a protected activity under the First Amendment, but some deepfake laws might implicate things like prohibition on forgery, fraud, defamation, false light, impersonation, and appropriation. But you have some states, like the state of California, that goes too far and passes a law prohibiting deepfakes that strikes at the core of what the First Amendment is supposed to protect. For example, political speech. And so some of you might be familiar with that fake Kamala Harris ad where she talked about how Joe Biden was senile. It was satire. It was parody. A judge ended up striking that law down as unconstitutional. But he didn't really talk about artificial intelligence being the tool, but rather the idea that you can create this sort of political content, and that's First Amendment protected. So there, he's thinking of artificial intelligence as a tool to just do something that people have always had the right to do. Intellectual property, this is probably where the biggest fights are, and where my thoughts on this are probably going to be the most controversial. I generally think that the outputs expressive artificial intelligence should just use the existing standards that we have. Like if one of these LLMs puts something out that is clearly copyrighted, then they could be held liable. But there's also the fair use test. Is it a transformative? There's a 4-factor test. So you can just use existing law surrounding fair use to determine that. The bigger fight is over the inputs. And I think it's helpful to have analogies, just like civil libertarians had analogies in the internet fight. I think authors who conduct research in a library or on the open internet and who use copyrighted material to create new material should be protected in doing so. If I read a book or a newspaper article, all copyrighted, and then transform it into some sort of new idea or build it, that would be protected speech. I think if you use a tool like artificial intelligence to help you aggregate and learn from that information faster, it should also be protected. In the same way that a painter inspired by a Mark Rothko painting should be able to create something that's similar to that, or someone inspired by a John Ford or Steven Spielberg film should be able to make a film in that same vein. And one of the civil libertarians from the early or late 20th century told me this. This is John Gilmore. He was an EFF co-founder, the fifth employee at Sun Microsystems. He said, if it's legal for a human to read a copyrighted book and to extract the ideas from it, it should be legal for an AI to read a copyrighted book and extract the ideas from it. It's about the reading, not the copying. Now, if the output is very similar to what the input, then you might have a copyright claim. But if it's transformative enough, then you wouldn't. So this is the idea that something that the AI puts out is defamatory of another individual. There was a case recently out of Georgia involving a radio show host who was told that ChatGPT said he was involved in an embezzlement scandal at a Second Amendment rights organization. And a reporter was using ChatGPT to gather more information on this lawsuit, and this guy's name, Mr. Walters' name, came up. And he did what you're supposed to do in those situations as a good journalist. He called up Mr. Walters and said, hey, I learned this thing about you from ChatGPT. I just wanted to see if it was correct. And Mr. Walters like, holy shit, no, that's not correct. And ended up suing OpenAI over this. Now, if this journalist didn't check with Mr. Walters and distributed that himself, he could be liable for defamation. But what do you do when it's the artificial intelligence? And I think this is a place where the law is going to have to kind of figure things out. Because Mr. Walters is a public figure. He's a radio show host. And with regard to public figures, you have the New York Times v. Sullivan standard that was then built upon to apply to public figures, not just public officials, that says you have to prove actual malice in proving a defamation claim. That is, it needs to be knowing falsity or a reckless disregard for truth. And essentially you have to prove intent. How do you do that with an artificial intelligence? Unless you have some sort of smoking gun where the coder says, if asked about this person, say this false thing about them, it's going to be hard to prove intent. It might even be hard to prove reckless disregard for the truth. So that's a place where things are going to be a bit murky for a while. But this Walters v. OpenAI case, the judge decided that he wasn't going to write in this new kind of defamation law for artificial intelligence. He was going to apply the existing standards that exist for every other medium. But again, those who share defamatory AI outputs will still face liability. This is where it also gets really difficult. Teen suicide cases. So some of you might have heard about these. I'll talk first about the Rain v. OpenAI case. This is probably where the facts are the most difficult. And again, these are just facts as alleged by the plaintiff, not facts as alleged by or rebutted by the other side. But you have a teenager here who started using ChatGPT first to just have conversations, later to talk about mental health, self-harm. It turns out it ended up getting into a place where this teen was thinking about committing suicide. The artificial intelligence, again, allegedly started talking to him about how to tie a noose, the carrying capacity of different nooses. They worked together on something that was called Operation Silent Pour, where the artificial intelligence, again, allegedly helped him figure out his parents' sleep cycle when they'd be in their deepest sleep, and that would be the right time to commit suicide. How to drink vodka to help dull the pain, even helped him work on a suicide note, allegedly. Now, these are tough facts. Anyone who works in the law knows that bad facts make bad law. But there's also the allegation, the speculation that this kid really kind of hacked the LLM, maybe tried to convince the LLM that he was writing a piece of fiction and to help him work out the narrative for that, not that he was actually committing self-harm. And we'll see how that plays out. But there's another case called Garcia v. Character Technologies. And this is the case where the judge said that she was not ready to rule that the First Amendment applies to artificial intelligence. And this was a kid who used Character Technologies chatbot to interface with a character based on Daenerys Targaryen from Game of Thrones. The allegations are that Daenerys Targaryen said kind of abstract things like, "Come home to me, my king." And the kid unfortunately ended up committing suicide, and his parents ended up suing over this. Now, this also isn't new. Like, this isn't a new artificial intelligence thing. People who are old enough will remember that Ozzy Osbourne was sued over his song Suicide Solution. Judas Priest was sued. There was a video game in the early 2000s, EverQuest, that was sued. Netflix has been sued for a film most recently. And while there's no Supreme Court case on these questions, we generally can put the law into two buckets. Abstract advocacy, so suicide is a rational choice, or general pro-suicide speech. Ideas are protected by the First Amendment. Even dangerous ideas are protected by the First Amendment. But when they veer into the realm of conduct, things like direct, targeted, and imminent encouragement, almost like you're participating in the crime, things like "do it now" or "here's how to commit suicide," these can be treated as speech integral to a crime or incitement, especially when it creates a direct causal link to the act. And I've been told I got 2 minutes. There are challenges associated with applying First Amendment standards to artificial intelligence, but I would say that those are challenges that can be addressed in large part by existing law. And whatever those challenges are, applying the Constitution to ever-advancing technologies needs to take into account free speech and First Amendment concerns, as Justice Scalia said in the majority opinion in Brown v. Entertainment Merchants Association that applied First Amendment standards to video games. And I would say also, we don't know what artificial intelligence is going to be. And so we should take a beat. We should learn, as Justice Oliver Wendell Holmes suggested here, that the life of the law has not been logic. It has been experience. And I think there are some experiences from past technologies that are transferable here. So in closing, I would ask, what are the risks of removing or eroding First Amendment protections in the artificial intelligence space? One, plaintiffs will be able to impose liability for the distribution of ideas in a way that courts have steadfastly rejected in other contexts. And the government will have almost limitless power to regulate, indeed to manipulate, what is bound to be a revolution in the creation and discovery of knowledge. And I will acknowledge here that these revolutionary technological advances are messy. The printing press revolution was messy. After that, you got centuries of war in Europe. You arguably got the 30 Years' War in Europe that led to 6 million dead. Are we worse off for having the printing press? I would argue we're better off, but then you also need to acknowledge the trade-off that you got millions of people dead in Europe. Hopefully we don't have that with artificial intelligence. But the internet revolution was messy. You have political polarization. You have widespread availability of pornography. You have all these other things that people are deeply concerned about. And I'd argue the AI revolution is probably going to be messy too. But technological progress is messy. And in sorting out that mess, though, we shouldn't also make a mess of our Constitution. As Justice Stevens said, we shouldn't burn the house to roast the pig. Well, I'm here all weekend, so if you have questions, you can talk with me then. Thanks.